Hello, California renters. Welcome to Martinez Law Center. If you are a tenant in California and you receive an eviction notice after January 1st, 2025, the rules have just changed massively in your favor. For years, landlords have used a speed lane in the court system to kick tenants out before they could even find a lawyer. But a new law, AB 2347, just put a stop to that. You now have double the time to fight back. Today, we are breaking down exactly how this new law saves your home. Before 2025, if a landlord served you with an unlawful detainer lawsuit, that's the official court eviction paper, you only had 5 court days to file a written response. 5 days. That is barely enough time to process the shock, let alone find an attorney or figure out the complex paperwork. If you missed that deadline, the landlord could get a default judgment, and the sheriff would be at your door days later. It was a system designed for speed, often at the cost of justice. Enter AB 2347. Effective January 1st, 2025, the California Code of Civil Procedure has been amended. Here is the bottom line. The time to respond to an eviction lawsuit has been extended from 5 court days to 10 court days. Now, 10 court days doesn't include weekends or judicial holidays. In real time, this gives you roughly 2 full weeks to get your defense together. This is a game changer. It gives you time to seek legal aid, consult with a private attorney like myself, and gather your evidence. But there's a second part of this law that most people miss, and it stops landlords from cheating the system. Under the new rules, a landlord cannot just sneak in a default judgment against you. They are now required to file proof that they actually served you the papers at least 3 days before they can request a default. This prevents those sewer service situations where a landlord claims they gave you the papers, you never saw them, and suddenly you're evicted without a hearing. This adds a critical layer of accountability. While we're talking about 2025 updates, keep an eye on SB 611. If you're looking for a new place after a dispute, landlords must now be totally transparent about monthly rates and cannot charge you hidden junk fees just for serving you notices. The law is tightening up on these predatory practices. Look, having 10 days instead of 5 is a huge victory for tenant rights, but it doesn't mean you can relax. An eviction lawsuit is still a serious legal emergency. You need to use that extra time wisely. If you've received the notice or if your landlord is threatening you, do not wait until day 9. I'm Mark Martinez. At the Martinez Law Center, we know how to use these new laws to protect your rights. Contact us today using the info in the description below. Stay informed and stay housed.